You have to hit that button at home. Okay, ladies and gentlemen, we're here for the Scoggins Subcommittee today. Before we start, let's pray. If you'll bow with me, please. Most kind and gracious Heavenly Father, we thank you for the opportunity to be here today. Please give us wisdom, and that all things that we do here today will be pleasing to you. We ask you to forgive us our sins, all of our shortcomings. Amen. Okay, Representative Carpenter.
All right, guys, we have before you House Bill 212. I think that currently we're working off of LC 280026. It's a really simple bill. It actually passed out of Senate for the past 2 years, and it passed out of this committee, I believe, last year, and we got hung up in rules. But basically, all it does is there's a little bit of gray area in the law in regards to issuing do not resuscitate orders with the hospital. And so it says they may, and this bill basically just comes in and says they shall do that because there were some issues with some folks with Edwards syndrome. It's called Simon's Law. And basically the doctor made a determination to do not resuscitate, and the parents didn't have any say in it. And so this bill is really simple. Just simply wants to
close that. There you go. Hey, just simply wants to close that loophole so that, parents know that they, have the right with what's going to happen to their children.
Okay, any questions for Representative Carpenter? Okay, what number are you? 7.
Thank you, Mr. Chairman. I want to thank Representative Carpenter for his presentation. And I told him that we would be doing this ahead of time, but we were able to pull Senate Bill 104, which passed out of the Judiciary Committee last year. It's in your folders today, so you can take a look at it. Looks to be, certainly as far as Section 2 goes, identical to the language you've proposed. It's just put in a different place, so it looks different, but that's there for you. The only difference is that there was also a definition of parent that was provided in Section 1 of the bill last year. And Representative, you have any thoughts on that? Any
Substitute. I mean, by all means, we need to have that definition in there.
Okay.
And then I also read through the ability, if a parent is not available, that you have listed down on lines 18 and 19, that there's an opportunity for hospitals to be able to address issues when a parent is A, not competent, or B, not available. So.
Okay, any other questions?
if I could
Okay.
follow up.
Yeah, I was just looking at that. I think it's the same. You all can tell me if you see something different, but Section 2 of SB 104 from last year is identical to your bill. And then we're just adding in the definition in Section 1. If I heard from you, have no objection to that
Yes,
amendment to add in what was Section 1 last year.
I'm sorry. Yeah, absolutely.
Okay.
No.
And then you asked about, you said you weren't sure about the line unless an exception applies pursuant to subsection E of this code section.
Yeah, and I have a copy of that here, so I read through that. I appreciate that. That's actually me dropping the ball on my homework.
No, I mean, that's fine. I think part of the conversation is because I just don't recall specifically from last year the discussion around this, but we went ahead and put the code section in the folders as well today so you could see how they pair up. And this isn't so much to the sponsor. I'm more directing this to the subcommittee for your consideration right now. But you've got does the committee, just a question I pose to the committee is, does there appear to be any conflict with the language unless an exception applies pursuant to subsection E of this code section and subsection E as you read it? So we've got the code section in your folder. Should be. And that's it for now. Thank you.
Okay, any other questions? I think we have a couple of witnesses. Joshua Edmonds.
Coming here. You mean to let him sit here? You mean?
You can slide down if you want to.
I will.
Come on up, Mr. Edmonds. Have a seat here. Mr. Edmonds, tell us your full name and who you're with.
Yes, sir. My name is Joshua Edmonds. I'm the Executive Director of Georgia Life Alliance. We are the largest pro-life group in Georgia and the state affiliate to National Right to Life.
Okay, go ahead.
Thank you, Mr. Chairman, members of the committee, for all of your time and your wisdom on this legislation. As you heard, this is a fairly straightforward piece of policy that is intended to shore up a line of code that would clarify the circumstances of which a do not resuscitate order could be placed in the medical file of a minor patient. And you all, it sounds like, obviously have a very good handle on the mechanics of that and the placement of that and the structure for that. I wanted to take an opportunity to share with you Simon's story. Because as we often see in these committees, we're talking about policy that has mechanical legal implications, but they come from very real life situations and stories. And the reason this bill is titled Simon's Law is because it is inspired by a very real story of a young boy named Simon Crozier. And his mom sent a letter here to your committee, I believe is in your folders, but she wanted to ensure that I conveyed her gratitude for your considering this legislation, which actually was approved unanimously by the Judiciary Committee in the House last year, as well as passing out of the Senate unanimously. It was just a matter of timing with the pandemic getting out of rules by day 40. But Simon was born in 2010, and his parents were elated that they finally had their sweet baby boy. And it became clear quickly that Simon had some medical complications. He had a cleft palate, and he also had Edwards syndrome, as you heard. And that typically comes with a long road of heart surgeries to ensure that he will be able to live a long, healthy, happy life. And it is not a condition that renders a person beyond hope. It is not a fatal diagnosis. It is just one that requires that our families and medical professionals continue fighting for those who are afflicted by it. And unfortunately for Simon, just a couple of days before his pre-op appointment was scheduled in December of 2010, his oxygen levels dropped too low, and his parents began asking for the medical professionals in the hospital to help, to render aid. And they said, "There's nothing we can do. This is the end. Enjoy the little time we have left." And there was no call to provide care. There was no code blue called. Simon passed away. And his parents learned tragically shortly after his passing that it was only because there had been a DNR placed in his medical file without their knowledge or consent that it happened. And had they been consulted, they would have not agreed with placing the DNR in his file, that they would have encouraged that they continue fighting. And like so many others who've been diagnosed with trisomy 18, Simon may very well be with us today, continuing to walk that long path to recovery, to full strength, but he would have been with us. And it was because of seemingly innocuous lines of code like this that permitted the situation to come to be. And so Simon's mom, Cheryl, has made it her mission to help ensure that this never happens to any other family again in any state in our country. This was signed into law in Missouri several years ago. And this, we've gotten right to the finish line here in Georgia to ensure that this never happens in our state again, to ensure that we protect patient rights, that we put in our code that the Georgia legislature believes that we should continue fighting for those who are medically infirm, who are facing these difficult diagnoses. And that is the burden before this committee today, is to join alongside those who are lending their voice to say that we're going to ensure that there's no more Simons, not in Georgia, not on our watch. And we're so honored to be a voice for Simon and his family. We're honored that this body has approved this legislation before, and we're honored to stand before you today to lend our support as well as the support of National Right to Life for Simon's Law today.
Okay, thank you, Mr. Edwards. We got a couple of questions. Number one, Representative Kelly.
Thank you, Mr. Chairman. Josh, thank you for sharing the story of Simon and his family. It's certainly heartbreaking.
Thanks, sir.
Was Simon did this take place in Georgia?
It did not. This transpired in Missouri.
Okay. I guess my question was, who entered the DNR if the parents didn't? How did one get into the file without I mean, who made that decision?
Simon's attending physician, because when Simon was born, he stayed in the hospital for 3 months. because of the medical complications and the need for him to have constant care and an impending surgery. He stayed in the hospital for 3 months. And it was just 3 days before his pre-op appointment that he went code blue, and it was because his attending physician placed that file. And because statute did not require that physician consult with and obtain approval from the parents, that he did not.
A follow-up, Mr. Chairman.
Yes, sir.
I want to certainly do whatever we need to do to make sure that no more, that we don't have situations like this going on in Georgia. But I wonder a little bit what the differences between Georgia law and Missouri law, if there was some inconsistency with the Missouri law that allowed that to happen, that may not be consistent with Georgia's law that would prevent this from happening already.
Well, thank you so much for your questions and comments. I think as you'll notice in the language of statute currently, that currently under statute, a medical professional may obtain parental consent before placing a DNR, but he is not by statute required to obtain that notification before. That's why the revision of may to shall, with the exceptions noted by Chairman Abstration and others, that it would be reasonable to have a recourse if you could not obtain that consent reasonably. But because code says may, not shall, physicians are enabled by the law to place that DNR without obtaining that parental consent. We're just saying that simple change to require that before it is done, they pursue every reasonable mechanism to obtain parental consent and ensure parental rights over that child's medical decision-making, that would rectify the situation here in Georgia.
And I certainly share the same goal with you. One just final question, Mr. Chairman, and I hope the answer is no, but do you have any examples of this that has taken place in Georgia?
We are aware of several situations in Georgia that this has happened, or similar situations where a lack of clarity in statute has enabled a situation where life-saving care was not given. I think you'll hear testimony shortly about another story of a child here in Georgia. There's also similar stories like down in Nashville, Georgia. We're aware of a young family whose son was born at 21 weeks. And because of the age he was when he was born, because he had not developed far enough along beyond 21 weeks, that he was denied life-saving care. And we recognize that every situation is unique, and we trust our doctors to make good decisions. We trust our families to make these heart-wrenching, difficult decisions. But when there arises situations when this body can make simple changes to statute to help clarify when these sorts of things may or may not happen, that's why we step forward with this, to hopefully never hear of these sorts of things again.
It's heartbreaking, and offline I'd love for you to talk with me some more about where this is taking place, because I want to have some further conversations maybe with the medical facilities where that's taking place. It's horrible, heartbreaking.
Absolutely. Thank you.
Thank
sir.
you.
Representative Walensky, what number are you? 11. Okay.
Thank you, Chair. Some question for whoever can answer, but I've heard a few times now we're switching it from may to shall, and I don't see a shall. So what is, when you say we're switching from may to shall, what is being switched?
What number are you?
I'm number 5.
Okay.
So I think you're correct.
Doesn't sound like.
How about now?
Okay, there you go.
All right, I think you're right. It doesn't say shall, but it says may be issued only. So I assume that's just a fancy way of saying shall.
Okay.
He means it the most
Representative
differential way.
Representative Walensky, does that answer your question?
I'll figure this out before the full committee.
Sometimes you use 4 words instead of 1 sometimes.
No, that's not.
You get paid by the word, I heard.
Yeah, I think there's a way to make it cleaner, but yeah, thank you.
I'm all for clean, baby.
That would be me. Thank you, Mr. Chairman. Yes. Okay, I was looking at the definition of parent, and the question I've got is, would a foster parent have legal authority to make a life and death decision in this? I'm just trying to define what that legal authority is.
If I may, Mr. Chairman. There was a considerable discussion last year in this very committee about what the proper definition was to ensure that those who had legal guardianship over a child in the situation were empowered to make that decision. I believe there was some consultation with DFACS to ensure that the language was correct. And if I heard Chairman Administration correctly, that this definition mirrors what SB 104 was last year. I obviously don't want to speak on behalf of the department, but I know that they gave their input to come to a place where they felt confident that this would cover foster care parents. It would cover legal guardians. It would cover biological and adoptive parents. They wanted to make sure that there wasn't a crack, so to speak, for a situation to fall through where a medical professional didn't feel that the adult present with a minor patient had the ability to consent to that DNR. And, obviously we can seek, further clarification from the department, but I do believe that the DFACS spoke in and ensured that the definition that you see before you was clear enough in their eyes that it covered foster parents as well.
Okay, thank you.
Thank you, sir.
Okay, any other questions for Mr. Edmonds? Mr. Edmonds, thank you for coming today. I
Thank you, Mr.
appreciate your
Chairman.
time.
Appreciate y'all very much.
Thank you. Would you get Taylor Hawkins, please? Okay, Mr. Hawkins, you will tell us your full name and who you are with?
Yes, sir. My name is Taylor Hawkins, and I am a policy associate for Family Policy Alliance of Georgia.
Okay, go ahead.
Thank you, sir. You all here today have heard the story of Simon, after whom this law is named. We have written testimony from Kimberly Minor, which has been submitted to the chairman. She is a mother of a young daughter here in our state. Her daughter, named Georgia, has the same condition that Simon had. And though children with this condition rarely survive past 1 year old, and that fact enters into the medical professionals' their equation as to what to do about the situations like this. Georgia is now 3, and Kimberly, along with many other mothers and families across Georgia, appreciate your consideration of this issue, and they would like to be sure that their children would be protected from a situation where a DNR is placed on their child without their knowledge or consent. I'd like to now read a statement from our Deputy Director, who is unable to be here today. Simon's Law is a simple bill that doesn't change any common practice. It is not an attack on our doctors or hospitals, but adds in a simple clarification in law that gives protection for families and patients. Many other states have passed measures similar to this, and it is time Georgia does as well. This bill has passed this committee unanimously and the Senate floor unanimously before, so it's time we get over the finish line. It's an important bipartisan common sense bill that could save lives and protect families. And we here at Family Policy Alliance of Georgia want to thank Representative Casey Carpenter for bringing this measure before the committee and ask that you all vote favorably for it. Thank you for your time.
Any questions for Mr. Hawkins? Doesn't appear to be any. Thank you for
Thank you, sir.
time. Okay, ladies and gentlemen, any other discussion from the committee? None? Hearing no more discussion at this time, I'll entertain a motion.
Motion to pass.
Have a motion to do pass?
Second.
Have a second? Any amendments?
Yes, sir.
Okay,
So proposed amendment is to insert the section 1 from Senate Bill 104. I'm sorry. Proposed amendment is to insert section 1 from Senate Bill 104 passed in 2020 out of the Judiciary Committee as an amendment to this legislation.
so your amendment is to add in section 1 the same language from Senate Bill 104 last year? Is
That's
that-
correct. I just asked to give legislative council a little leeway to do what they need to, but to add in what was section 1 from Senate Bill 104, which is before the committee members.
Okay. Any further discussion with the amendment? Okay. Hear a motion on the amendment? We have a so move on the amendment?
Right.
Okay. And we have a second? Having received a second, all in favor, say aye.
Aye.
Opposed, same sign. The amendment passed. Okay. Okay. Any other amendments from anybody? None? Okay, voting on, ask for a motion on do pass on the House Bill 212 with the amendment.
So moved.
Okay. Here a second? Okay. All in favor of House Bill 212 as amended, say aye.
Aye.
Any opposed? Okay, bill passed to full committee.
Thank you, Chairman. And just real quick, I know a lot of you guys got an email from Ms. Minor, and I just want to give her a public shout out, if you will,
For sending that email, Miss Minor. We appreciate you, and we hear your struggles, and you know, we're just proud of how far Miss George has come, and proud of you for sending that letter to kind of let us know, give us the personal touch of what's going on in Georgia, and we just continue to pray for her health and your energy levels to as you go through that process.
Okay, thank you, Representative Carpenter, for bringing that bill. It's a good bill. Okay, Representative Lim, come on up. Go now. Okay, hold up, Ms. Lim. We'll get you last. Okay. Representative Maynard, come on up. Okay.
I asked the same question in committee last year. Same thing you did. So, yeah.
Good afternoon, Representative Maynard. How are you? Good. Good. First time we met today?
Yes.
Yes. Glad to have you here. Okay, if you will, tell us about your bill.
Okay, so House Bill 138, before I go into the information that was passed out to you, I want to tell you how this bill came to play. There was a minor in an apartment building. She lived on the floor where the pool was in this apartment complex. She was taking a shower, and a naked man came into the shower and tried to attack her. The apartment complex decided that they were not going to let the other parents or people in the building know that this had taken place. The problem with that is many children were taking showers in this pool area. The police said that it is considered a peeping Tom issue. And so what I put in this draft is not only just peeping Toms, but when you think about residents or tenants living somewhere, they're expecting the landlord to protect them. That's what they're paying their money for. So this says to the landlord, just protect us, right? Let us know if something is going on so we can at least be aware of what we need to do. Give us the option to know what's going on in our building. I have a letter from attorney Matthew Hollingsworth. He just dated this today. I'm thankful for him sending it. He is actually a negligent security attorney. In his opinion, this helps victims, right? It allows landlords and apartment dwelling owners to step up to the plate. And actually, this will decrease the amount of negligent security cases because now the apartment buildings have more accountability for protecting their residents. This next piece that says it's from a newspaper article. There are a lot of gang activity going on in the state of Georgia, and our governor has picked up the bill for this saying gangs are not tolerated, especially in the metro Atlanta area and all over the state. Gang activity has increased, and unfortunately, the tenants have no idea if they're even susceptible to these crimes in the buildings that they live in. I put this in here because the article also goes into saying a lot of times when you have one crime, you have multiple crimes. And so in this particular case, it's domestic violence and a gang-related activity. And both of those crimes are on this bill as far as a report. If you see this list, this is from the GBI's website of their crime statistics. From 1980 to 2016, the whole purpose of this is to just show you all these crimes are increasing, right? Which means more and more people are susceptible to being in unsafe environments. So what the bill says is only twice a year, the landlord needs to notify tenants and prospective tenants these statistics of that particular building. I have spoken to the Georgia trial attorneys, and to my knowledge, they have reached out to some committee members to let them know that they're in support of this. Also, the Cairo Housing Authority. Surprisingly, I wasn't expecting the Housing Authority to be on board, but in their mind, this is an important bill because they want their residents to be safe, and they have multiple children that live in the housing authority. So they think that this is a good bill. Any questions?
Okay, Chairman Administration, I think you have your button raised.
Thank you, Mr. Chairman. Thank you, Representative, for your presentation of the bill. I had a question previously about the means by which the landlord would be able to get this data. So I'm familiar with open records requests made to municipal and maybe county police departments, the availability of records and the difficulty sometimes with getting those records. Have you, what consideration has been given to that? What about circumstances where landlords do what they need to, but they're unable to get this data, so they can't comply with the laws as would be required from your bill?
Right. So I did speak to the housing, not the Georgia Apartment Association. They did bring this matter up to me for a concern. So since it's twice a year, you have 156 days or so, 175 days or so to actually get that data. Open records request is 30 days. So if a local law department is having trouble getting them the data, there's ample amount of time where they can still be able to get that data.
In my experience, a lot of times open records requests can be made with a 3-day deadline that's required by law, but still the information is not provided and follow-up can be required. And so I'll just tell you, as I review that, that's just kind of something that jumps out to me as a potential concern. But I think the purpose and objective of ensuring that people are cognizant of security concerns is one that I certainly understand. I applaud your work to try to address that. That might be something that I would just come in to work on, because if a police department, and I'm mainly talking about municipal organizations, because maybe county government would have the open records responses quicker. But if a municipal police department is unable to or unwilling to provide that data, even a 6-month requirement could be a great obstacle to compliance with the law, in my view. But I'm interested in any response that you have to my comments or the concerns that I have.
I do, especially in front of a board full of attorneys. My question would be back to you is, why wouldn't a municipality be able to provide those records back? So that seems like that's a whole nother problem that has nothing to do with this. So if there's another challenge there, then we need to create legislation to make that not a challenge.
Thank you.
Okay, Representative Walensky.
Thank you, Chair, and thank you, Representative Maynard, for bringing this great piece of legislation. We've met before. You know, I'm an attorney, but I'm actually a serious injury wrongful death attorney, and I do handle negligent security cases often. This bill, I agree, is very helpful. It is very needed. When it comes to premises cases, the question is superior knowledge. Who knew more of the hazard? In this case, a lot of the cases are shootings or crimes or anything like that. So it's 100% true that if an apartment complex shared this data with their tenants, that it would decrease the ability to then go after them for a crime, because you can't argue that the tenant did not know this was a high crime area or what dangers were around. So I do agree that this would be good for knowledge of the tenants. It would reduce the amount of cases. At the same token, I do agree with the chair. I've been doing this for 12 years, and I've brought up many times that there's an issue with open records requests, and many people who are involved with them, there is a problem with getting them. So I would add to that, that there should be something here that says, you know, that they need to follow this. And if they made the request and haven't been able to receive the specific info, they still need to provide the tenants as much information they can gather and keep following through until they get it and need to show that. But there does need to be something, I believe, where, I mean, you can request, and if they won't produce it, you can't really do anything about it. So it's a great bill, and I think just with a little change, I think it will be a perfect bill.
Judge Gunter.
All right, thank you, Mr. Chairman. Representative Maynard, my question has more to do with the notice that's provided. And I guess the way I'm reading this here is what the concept is to hand out a document. Is that correct?
So, you know, a lot of times when we're like, I'm saying this as if I've been here for a while. I've been here for 14 days. But a lot of times when we create legislation, we don't want to be too narrow in the legislation. We want people to be able to execute it the way they see most fit. So the idea was, if the apartment complex chose to send out an email, it could be an email. If they chose to do it in a handwritten letter, if they chose to do it in a text blast, if they chose to put it on their website, I wanted to put no burden on the apartment, so they could really choose to do that on their own, however they best saw fit. And if I may respond to Walensky, I'm open, of course, to amendments at your suggestion.
All right, and follow up, Mr. Chairman.
Yes, sir.
So email, hand out a copy, posting it, would that also?
On their website, or even some communities have text communication. So in this particular case, where this 15-year-old girl was almost attacked, and I want to say she was is a straight A 4.0 student, never seen a naked man in her life. So this was traumatizing for her. But in this particular complex, this was in Midtown Atlanta, rent $2,500 a month. And there are loopholes in the system, right? But this particular complex, they have multiple means of communicating with the tenants. So they do the text blast. They have an app where they can notify people on the apartment app.
Okay, and a further follow-up, Mr. Chairman.
Yes, sir.
And is this a continuing duty to the tenants that are at that apartment complex?
So in the legislation, it just reads, report it twice a year, right? So you have 6 months to get data, and then you only need to report the data for the previous year. So if you had a lot of murders, 2 years back, it doesn't count against you as far as when a tenant is trying to decide if they want to live there or not.
But the tenants that are already there, there's a duty to continue to inform them of the crime
Twice a year, yes.
twice a year. Okay, thank you.
Representative Walensky.
Thank you, Chair. I'm just going to add in response to Representative Gunter's questions. Many apartment complexes, many the ones that we don't worry about, the good ones are doing this already. So this is important for ones in high crime areas, otherwise that don't have this as part of their standards, where the other ones do. This is something that needs to be in all apartment complex standards. And it usually is done by an email. I didn't know about text, but for many, this isn't going to be a big change. And for some, this is an important change.
Okay, let's go to Representative Dryer on Zoom.
Thank you, Mr. Chair. Thank you, Representative Maynor, for bringing this bill. I do agree that this would help protect people. It would help keep people safe that live in multifamily complexes. So thank you for bringing it. And I want to raise another issue, but I suggest we don't add it to this bill because I don't want to slow it down. But we see some of the gravest safety concern in short-term rentals, weekly motels and hotels. And maybe we can work together on addressing that in the future, but we don't want to make this more difficult than it is. So for now, thank you for bringing this. And I think, we can do some more work in the future to keep people safe.
Thank you, Representative Dryer.
Okay, Representative Rich.
Thank you, Mr. Chairman, and thank you for bringing this. I like that you're thinking about how to protect people who can't protect themselves. So I have two questions along those lines. Would you be opposed to any of the onus or responsibility being put onto the tenant to obtain the information?
I would be open to that. The question is, would it be mandatory as part of their lease agreement where they have to go in and get it? A lot of times I have found, especially in marginalized communities, they already don't know how to get information. And so when you say, go do something, they already don't know how to do basic things.
So maybe a notice in the lease that would tell them where to go to find it would be good.
It's a
Just something to
step.
think about. Okay.
It's a step.
And then my second question, if I may, Mr.
Okay,
Chair.
yes.
Does this apply to public housing as well as privately owned housing?
So in the legislation, it doesn't say private versus public, but the Georgia Housing and Redevelopment Authority, I received a letter in particular from the Cairo Housing Authority that said he definitely supports this bill, and that would be a public agency.
Okay. All right. Thank you.
Judge Gunter.
All right, thank you, Mr. Chairman. One more question. By putting this into law, does this create a duty for the apartment complex that they would have liability for? What I'm thinking of is Chairman Estration's point about not being able to get the information and provide it. And if something happened, would it create a liability for them? I didn't know if you've looked at that or not.
No, so it definitely puts some liability on the apartment building, right? We can't get around that. And so the question is, do we look out for the apartment building, right? Or do we look out for the 15-year-old girl that might get attacked? And it's not that she might get attacked, it's the fact that the apartment building right now does not have to tell anybody that this happened. So to this day, there could be a man still watching children in this same apartment building because they don't have to tell people that there's a security loophole.
Thank you.
Any other questions for the author? We have a couple of people to speak to the bill. One is on Zoom, Hayden Stanley.
Thank you, Mr. Chairman, members of the committee, and Representative Maynor. My name is Hayden Stanley with 5 Ash Stanley, and I'm before you this afternoon on behalf of the Georgia Apartment Association. The members of the Georgia Apartment Association develop, build, own, and manage apartment properties throughout Georgia. Members of the association's legislative committee reviewed House Bill 138, and they've asked that I convey their questions and concerns to you. As discussed, Section 1 of the bill would place a new requirement on apartment property owners to first obtain and then provide a summary or a listing of all crimes involving the commission or attempted commission of various crimes which are specified and which were reported to or investigated by law enforcement agencies that occurred on or in that property. And then Section 2 provides that that same information be given to prospective tenants. And finally, the third section of the bill would make failure to comply a fair housing violation. And even more than the requirements added in Section 1 and 2, this provision causes heightened concern given the purpose of the Fair Housing Act and the penalties that are provided within. So OCGA 83213 provides, among other things, for up to a $10,000 fine if the respondent, meaning the apartment community, has not previously been found guilty of committing a discriminatory housing practice, which this bill would, the way we read it, assign this as such. Up to $25,000 if there's been one, and then up to $50,000 fine if there have been two such incidents over the past 7 years. And then finally, within that, that I would like to highlight is, in addition to those remedies, the court may award actual damages and punitive damages to the aggrieved person. So Representative Gunter had asked about the liability. Certainly liability currently exists, but the consequences and the added liability are severe in this bill. The members of the association oppose the added requirements within 138, which they frankly believe reassign the responsibility of law enforcement and local government to a housing provider. The common practice for the members who have replied to our request for information is that management shares information on a relevant need basis to stay ahead of any liability. So in effect, if there's one car break-in, it's unlikely that there's going to be broad notice given. But if there are something out of the ordinary and there's a spike or there are several car break-ins or serious crime in the area or on that property, the common practice is to alert the residents, and they let them know. Also, if a resident or prospective resident asked about it, that information is also provided. Most typically, when there are requests, they refer them to local law enforcement. But beyond the general concern with the shifting of responsibility for crime data reporting to property owners, there are a number of implementation questions. Appreciate Chairman Efstration's question about along the lines of obtaining this. Is there a uniform way in which data on crimes is maintained by law enforcement? And are all of the reports going to look the same and use the same terminology? How do the owners request it? Is the Atlanta Police Department going to respond to hundreds or 1,000 individual requests for property specific crime reports? Is there a way to download it without waiting on the police to do that? And then ultimately, at the end, how does this property owner who would now be subject to additional liability concerns, how do they know that they have true, correct, complete information? And to the police departments or the local government, they have to provide it. And if they do, how does the owner know they have all of that? So we appreciate the opportunity. I appreciate Representative Mainer's time to discuss this, and I'm sure that we'll continue to have dialogue. But the way the bill is structured, the Apartment Association rather, and their members do not support it. Thank
Okay,
you.
got a couple of questions, Mr. Stanley. Representative Lewinsky.
Hey, Mr. Stanley, how you doing today? Thanks for being here.
I'm well, sir.
And I definitely have heard what you say. Section C, I agree with you. And the fact that it says reported to or investigated by maybe too high of a standard. So I agree with you. But a few things you said caught me. I mean, it is the duty of an apartment complex to provide safe premises for their tenants, right?
We'll defer to you on that.
And I'm going to try not to sound like I'm deposing you here. And then it is a common practice for apartment complexes to keep up to date on the crime in the area.
It is.
Okay. So, I mean, I do think most apartment complexes are doing this. And I do think this bill is not perfect, as I said, but I do think there's a place for it if done correctly. And I know in years past, you've worked with people on bills to come together to figure out how to make this work. But with email, text, Reddit, there are many ways to inform people these days. And I think informing people of crime in the area would be beneficial to the tenants, and it would reduce liability because, once again, the tenants would be highly aware of their surroundings and what dangers are around. Thank you for being here.
Thank you, sir.
Any other questions for Mr. Stanley? None? Thank you, Mr. Stanley, for being here today.
Thank you, Mr. Chairman.
Okay, we have one other witness. I'm sorry,
Thank you, Mr. Chairman.
Representative Burchett, or Chairman Burchett.
Thank you, Mr. Chairman. I just had a quick question, and forgive me if it was asked while I was out. In just reading this line 11, it says the landlord or manager of any apartment building or complex. Is complex defined in the code somewhere? And what would a complex be?
So I'm going to have to defer to legislative counsel.
Okay. That's all I have.
Okay, go ahead.
I would like to just respond to Hayden. We did speak earlier today, and the most important thing is tenants are notified, right? And apartment complexes do have due diligence to protect the residents that are paying for that living habitat. With Mr. Hayden, and I believe that's his first name and not his last name, so forgive me, he saw no room for any compromise, right? So that's an issue, right? So the board has said that, you know what, I feel like there are a few things we can tweak in here to make this bill work, because it is important to notify victims. And as Representative Walensky said, it's easy to notify people. This law puts no limit on how you notify the person. And that's I just want to make that point. That I'm willing to compromise, but the apartment association is not willing to compromise.
Okay, any other questions from the author? Okay, Representative Maynor, we're not going to take a vote or action on this today. There's a lot of concerns and a lot of questions been by a lot of different representatives and witnesses, and we just feel like the best thing to do at this point in time is maybe you just set up a time with Chairman of Administration to maybe talk. And then at that point in time, we can come back and maybe face this issue sometime down the road.
That sounds perfect. Thank you.
All right. Have a good day. Okay, Representative Lim. How you doing?
I'm doing well. How are you?
I'm
Chairman
doing good.
Scoggins? Good.
Okay, you're here today for House Bill 183 LC 364503.
Yes, that is
Okay.
correct.
All right, if you will, tell us about your bill.
Absolutely. So I'm pleased to speak about HB 183. What this bill essentially does is to allow businesses to file suit under the Georgia State Fair Business Practices Act, which is an existing statute that outlaws unfair or deceptive trade practices. And that includes things like passing off the goods of another as your own, or making false statements about or disparaging, in fact, another business. So despite the fact that in those couple of examples that are listed in the statute as outlawed by the FBPA, if I may abbreviate it, only consumers as, quote, natural persons are currently allowed to file suit under the FBPA. And the FBPA allows for private actions for damages, as well as to make complaints to the Attorney General for investigation. So what this bill seeks to do, and you'll see it in, I believe, Section 2, is to allow for those, quote, representative capacity lawsuits. The individual, again, refers to consumers as natural persons. Currently, only the Attorney General is allowed per Section 1 to make those representative capacity suits. But as I stated, businesses are clearly under the ambit, or could be under the ambit of this act, because they could be harmed by other unfair or deceptive trade practices. So 2 more points on that. One, I did want to point out that this is something that at least I did not have time, despite being a lawyer. I love 50 state surveys. I can only do a survey of our neighbors, but I do want to point out that Alabama, Florida, South Carolina, and Tennessee allow businesses to sue under the analog of their state laws. They call them different things. Allow businesses to sue for damages under their analogs of the deceptive, or rather the Fair Business Practices Act. And the second thing I did want to note is, while you might believe that businesses have other means to pursue claims, whether that's in common law tort or contracts or what have you, I'm particularly thinking of a lot of small businesses that would be benefiting from this kind of provision that would allow for private suits as well as AG complaint. I'll close by saying 2 examples of those are actually in case law. One is called Friedlander versus PDK. That's a 1996 Supreme Court of Georgia case where a business tried to do this. And then the following year, there's a case called Lone Star in the 11th Circuit. In those cases, both of those courts stated that as the Fair Business Practices Act currently exists, those businesses could not pursue it. I'm seeking to change that because, as per those 2 examples, there are businesses that believe that they can avail themselves of this provision because, again, clearly unfair and deceptive trade practices can harm businesses as well as consumers.
Okay, any questions? Chairman Administration?
Chairman, and I want to thank you, Representative Lim, for bringing the bill. Just to maybe understand this fully, if I could ask just a series of questions, and you please stop me if or let me know if I'm not in the right line here. But under current law, you only have standing if you're a consumer. If you're a business that's been harmed in some way, you could not seek remedy under the Fair Business Practices Act, and your bill is seeking to address that. Is that right?
That is correct.
And but it would still be necessary for a business to demonstrate that they had been harmed in some way in order to seek such recovery. Is that right?
That is correct.
Okay. And really, Justice Carley's opinion in Freelander was really based upon that there was not explicit statutory authorization for a business to bring such a claim. Is that fair?
That is correct.
All right. Could you give us maybe an example of how this might play out, just a hypothetical of how this might play out, so that committee members can just visualize when this might come up and what the need might be as you see it?
Absolutely. So the first harm listed under the Fair Business Practices Act is, quote, passing off goods or services as those of another. One can imagine, and again, this is in the hypothetical realm, that business A claims another business's goods as their own because they want to have the capital or the goodwill from that business attached to their name. So you can imagine that they're actually taking business away from business B by claiming business B's goods and services as their own. Another example, I mentioned it earlier briefly, is disparaging through false statements or representations another person's goods. So you can imagine that by disparaging another company's goods, that would drive down their sales, their revenue, et cetera. So those are things that we can clearly happen. And of course, at this level, it's very difficult to claim that if they're doing it on such a small scale that you could prove that. But you can imagine on a larger scale, it doesn't even have to be that large, but something that's more than one time or a second time, as a lot of this is. A lot of the unscrupulous businesses do this multiple times. You can imagine that they would not only harm another business, but that a business could meet that standard to show harm. And again, under this particular bill would be able to sue.
And, you know, we here in Georgia are very proud of the fact that we've been recognized as the best state in the nation to do business for, I think, 7 or 8 consecutive years at this point. It's a really big deal. And we want to make sure we've debated legislation about how bills through judiciary might or might not impact it. In your view, is your bill going to erode Georgia being the best state in the nation for business? And I know you talked about a survey that you've done as far as some of the other surrounding states. Have you noted any decline in business because of the implementation of a similar standard in our neighboring states?
That's a great question. I personally looked for data, and it wouldn't be statistical anyway, but I haven't seen even anecdotal qualitative data in those 4 other states I mentioned. I do want to make clear there are a number of other states beyond our neighbors that also allow for this. I haven't seen even anecdotal data that shows that they have been harmed by having these provisions. And to me, that makes sense, because to me, this is a pro-business and particularly a pro-small business bill. Again, we're trying to go after, particularly those unscrupulous businesses. And oftentimes, yes, the larger corporations, as I mentioned, can bring claims in common law or perhaps other forms of statutory law, but those smaller businesses cannot. And I think a great part of what makes Georgia so good for businesses are those small businesses that don't have those means, or it'd be more expensive to them. That's why I think this is pro-business, because it helps particularly those businesses, and it provides them, again, not only that private action for damages, but also for investigative complaint mechanism under the AG. Now, the AG doesn't have to investigate anything. Of course, the AG still has that discretion, but I think the AG would be interested to know whether there might be that business-to-business dispute, particularly those that harm small businesses. So in conclusion, I think this is something that would help our reputation as the best place to do business in the 50 states.
Thank you.
Representative Walensky.
Thank you, Chair. I'm just looking at the Florida law, and one interesting thing about that is it allows businesses to sue for an injunction. So you may want to add to your bill the idea of an injunction. The other thing it talks about a lot, just dealing with Florida, and I didn't have enough time to get even to the 4 states, is that it says that part of their is that there must still be harm to a consumer. And I'm not sure if your bill addresses that. So if we're going to throw in the idea of business to business, I think those 2 ideas may want to be added in. Thank you, Chair.
Oh, yes. May I respond to that?
Yes.
Yes, I would be supportive of adding an injunction. I do want to note that while it's not the same thing, we also in the state have the Uniform Deceptive Trade Practices Act. That's something that covers a lot of the same things, not everything. In fact, we just added something this morning with travel insurance to Fair Business Practices Act effectively. But that UDTPA does provide for injunctive relief. Now, that said, I would be supportive of adding it here. And as far as consumers under the Florida law still having to show, or rather that there still has to be evidence of consumer harm, I think, again, with those couple of examples I proved or showed rather or discussed, those are things that would create consumer harm in the first place. So it's something that both harms consumers and businesses often at the same time. It's just you're leaving consumers who themselves often don't have recourse to make those lawsuits. So I do think that a lot of what is outlawed, the practices outlawed under this, are part and parcel consumer and businesses, and I'm simply allowing businesses to also enforce their rights.
Judge Gunter.
All right, thank you.
Okay.
Representative Lim, my question is, I'm thinking of Ford versus Chevy and the commercials that, especially when Ford came out with the aluminum body and they were talking about how cheap it was. I mean, does that fall under this? And could that result in a lawsuit under the Fair Business Practices Act?
I will say that with the caveat that I don't know all of the facts, and that is a body of law in itself, disparagement, false advertising. I will say theoretically it does. Again, to my knowledge, there is a rather high standard for that because a lot of it can just be what's called fluff. And we know a lot of lawyers know that that's not something that would be actionable. So theoretically it could be, but the standards would still apply that
I
exist.
guess what I'm at, this doesn't change any of that.
Correct.
Is that okay?
Correct.
Thank you.
Okay, any other questions for the author of the bill? Nothing on that? Okay. Okay, did I hear a motion?
Move to pass. Second.
Okay, we have a motion to do pass and a second. All members in favor say aye.
Aye.
All opposed? The ayes have it.
Okay.
All right.
Thank you, Mr. Chairman. Thank you to
you.
the subcommittee.
Okay, ladies and gentlemen, that ends the committee today. Thank you.
We'll have a full committee tomorrow, 1:30, and there's lunch available in here at noon for judiciary members.
Okay, I got that. Okay.